Alex here with part 88 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that we will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Going into part 88. We are going to actually have a pretty short video today. This is a document that I think is important, but it's not a very lengthy document, and because it's a one of our main filings, it isn't really, it doesn't do it justice to sort of just tack it on to another video. It's basically my response to Bank of America's resistance to the writ of execution that I filed, and it has to do with a law that they cited that doesn't apply. And I guess we could talk a little bit more about that when we get into the actual document. But for the most part, this is a continuation of my efforts to execute on my ex's bank accounts. And I know that there is another point in time where I filed a writ of executions on her employer, but that's going to be probably coming up in the next 1 or 2 videos of the My Docket series. So I suppose, oh, by the way, my mindset at the time was mostly positive. I have to say that I still sort of felt dismayed by the court with its handling of the emergency motion that I filed. My son needed to get surgery. But at the same time, Wes Ayers and his handling of the discovery issues, and then the fact that my family judge gave me both a debtor's exam and a judgment on arrearages, those gave me the perspective that the court wasn't really looking at these issues in sort of a big picture, beginning to end sort of approach. It was just taking each issue that came before it at that moment in time. So I was starting to realize that the judge just really didn't remember me. I mean, he could remember in a sort of fuzzy way that I was the guy that filed a bunch of papers and that this was the tough case, but I don't think that he could remember specifics like the fact that we were doing midnight exchanges, that I'm not even sure that he knew the custody designation we have. It's like most of the things that I would have thought that the judge would have known and kept track of, he really didn't. And I started to realize, well, he was not very nice to me at that last hearing, but I just won 2 motions. So does he like me? Does he not like me? And of course, that whole way of thinking is wrong, and that's why I did the video relating to the judge and also the machine. 2 very good videos that teach you to stop trying to sort of connect to the judge on a personal level and to see the legal system as a whole as more of a machine and less of a body of people. So anyway, at this point in time, I think it's good for us to go ahead and take a look at what I have filed. Here we have my reply to garnishee's answers, required by writ of execution. This is something that we used to do to what we called garnishee defendants when I worked in collections at 2 different collection agencies. In fact, actually, now that I think about it, the second collection agency that I worked at was not very fond of using these, but the first one, well, even the first one wasn't very fond of it until I showed the owner that this was possibly a remedy that we could use. Once I showed the owner that this was a remedy that was available to us, not only was he excited about it, but I ended up getting some pretty big bonus checks between, I think, September and December. And what I found out was that you can go after a garnishee if they do not comply with the writ of execution. And you can go after the garnishee in 2 ways. One of the ways is you can ask for them to be forced to pay a penalty of $1,000 for defiance of the court's order. That one isn't really popular, and I don't remember it ever working. We would ask, but we would never get it. The second one is the one that almost always worked, and that is the request that the garnishee defendant pay the amount that you would have received had they complied with the court's order to levy the account or garnish the wages or whatever it was. So to make it a little bit more simple, or maybe easier for you guys to understand, let's say that I issued a writ of execution. I wanted to levy a bank account. The bank account had $350, and the bank defied the order of the court to do so. Or in this case, the writ of execution, which is through extension of the judgment in order of the court. But anyway, let's say that they did not do that. You could go after them using some statutes in Nevada that allow you to do this. I don't think there's any other sort of common law or any other approach that allows it. There's strict statutory language that specifically says that you can do this. Using those statutes, you can then get the judge to order the bank to have to pay that money for the debtor out of the bank's own assets, which then allows you to execute on the bank if you have to do that. And we did do that when I worked in collections. There were more than 24 examples of a garnishee not complying with the writ of execution. Usually they wouldn't reply. Sometimes they would just say, no, we're not going to do it because we don't want to. In both situations, you can go after them, and it's a little bit of a process. I think it's instituted by filing a motion for order to show cause against garnishee defendant, and then you appear in court and you explain to the court, this is the writ of execution, this is the date it was served, they have not complied, we would like a judgment against them for this amount of dollars. And most of the time, maybe 95%, 99%, I can't remember actually any time where it was denied, not off the top of my head anyway, the judge would grant that request, and then we would have a judgment against the garnishee defendant. Now, a lot of people wonder, why go through all that effort? Well, the reason is because employers, banks, these people actually do have assets, and you can execute on these assets. For example, we had a Verizon Wireless employee. They lost the case. I think they just defaulted. We got the judgment against them. They didn't pay. Then we issued a writ of execution to their employer, Verizon Wireless, and Verizon Wireless completely ignored it. They didn't garnish their wages. They didn't do anything about it. So then we went back to court, filed a motion for order to show cause against the garnishee defendant. Verizon Wireless didn't even come to court. They sent the employee for some weird reason. And I remember the judge saying, well, it's nice that you've come, but this isn't, for you. This is for Verizon Wireless. So since they haven't appeared, we're going to go ahead and enter the judgment against them. And so the amount of money that this employee was supposed to pay, they ended up not having to pay, because as soon as we got the judgment against Verizon Wireless, we immediately tapped all their tills. So the sheriffs, the deputies showed up at the Verizon Wireless store and emptied out all their cash registers. And so they ended up having to pay the debt for the garnishee defendant because they didn't take the money out of the garnishee defendant's check like the judge told them to do. So you can do stuff like this. In this particular situation, I was thinking about doing this to Bank of America, but I found this other statute that said you can force a garnishee defendant or a garnishee to explain why they are not in compliance with the order of the court if they have given you an answer that's not suitable. And that's what happened in this case. Bank of America was not ignoring me. What they did was they provided answers to the interrogatories stating that the money that I was trying to take from my ex's account was exempt from execution because, and actually, let's go ahead and just take a look at this now. You can see that the bank cites NRS 21.105 subsection 2. So I am using the law, which is over here, NRS 31.330 subsection 1, and you can read it down here in the footnote. It basically says if a garnishee answers as required by the writ, I can, within 20 days of expiration of the time allowed for the filing of such an answer, I can then reply to that particular answer that's been given by the garnishee, and I can state, or I can challenge them, which is what I'm doing here. I'm confronting them. I'm saying, I got your answer. I realize you're citing NRS 21.105. I am going to challenge you and say that law doesn't actually apply here. And this is how I do it. Garnishee defendant Bank of America avers in its answers to interrogatories that my ex has no monies in excess of exemptions. And this is the law that they cite, NRS 21.105. If a writ of execution or garnishment is levied on the personal bank account of a judgment debtor, $400 or the entire amount in the account, whichever is less, is not subject to execution. So they're basically trying to say that she has less than $400 in this account. And then I here highlight in bold, unless the writ of execution is for the recovery of money owed for the support of a person. So I'm saying, yeah, you're right about this, Bank of America, but there's an exception, and this exception applies because the money that's owed is for the support of our son. Because the judgment and execution are for the support of a person, specifically our common minor child, this exemption does not apply. The writ of garnishment prepared by the Washoe County Sheriff's Office clearly states that the execution is for the support of a person. Furthermore, the calculation of garnishable amounts specific to deduction states deductions required by law, not including child support. So on multiple different areas, levels, whatever statutes, I have Bank of America basically called out as wrong. They're citing the wrong law. They cannot rely on that law to protect my ex's assets. Subsection 2, and here is where I warn them. According to Chapter 21 of the Nevada Revised Statutes and a couple of cases that I've cited, if you do not comply with that writ of execution, I can get a judgment against you, the bank. And going into the next portion here, we have the standard stuff, the affidavit in support of the reply, which indicates that I am swearing under penalty of perjury that this reply is true and correct, and my certificate of Rule 5 service, which is that I served upon both my ex and Bank of America this reply, which is allowed by law. And the next portion here is the list of exhibits. We're going to go through exhibits 1 and 2 really quickly. Exhibit 1, and here's the interrogatories that the bank responded to. Rather than go through these, I'm going to go ahead and let you guys go through them. If you really care, you can post something down in the comments below and we can talk about it. But it's just, these questions are outlined by statute. I didn't invent these questions, nor did Bank of America. The legislature invented these questions, and they put them in a statute. And so Bank of America has to respond to these questions because the law says so. And these are the responses in bold. And yeah, like I said, guys, take a look at this. If you have any questions, we can, of course, talk a little bit about it in the comments below. But that's the nutshell of what these interrogatories are. They're special interrogatories. They're not the typical ones that are used in a lawsuit. In fact, if you want to know what I'm talking about, please watch the video, Interrogatories. Here we have Exhibit 2, and this is letter. This is the letter from the sheriff. This is, I believe this is the writ of garnishment. It is. So the sheriff has this letter that they send to the bank on my behalf, and it states to the bank that you are required to respond to the interrogatories. You are required to seize these monies and turn them over, stuff like that. So this is the only document we're going to be going over. I do want to let my viewers know what was the outcome. The outcome was that Bank of America reviewed my reply and gave me the money. So they realized they were wrong. They didn't apologize or anything. They just cut me a check. And the check went directly to the sheriffs, and then it was held there for about a month, and then the check came to me. Going into the aftermath, I filed 1, 2, 3, 4, 5 documents, but they were not all free filings. Most of them were free filings, but those 2 writs of execution cost $20, and then there is going to be some service of process costs that are going to be connected to the $20. So rather than give you the exact dollar amount, I'm going to do the math afterwards. You'll see it slide up next to me. It probably already has, and that's the number. My ex has not filed any documents, so she's incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably not even cared to look at either of the writs of execution, so I'm not even going to count those. The notice of intent to modify custody, I doubt she cares. And it's not that she's an attorney. She's going to care about what she needs to respond to. It's a job for her. So if she needs to file something, she's going to care. But if she sees me file a document it's just there for her, she's probably not even going to read it. She probably doesn't care. Maybe she'll forward it to my ex in an email and say, here's something Alex filed. That's it. Something like that might happen. So we're looking at maybe 2 minutes there. The minutes were something that the attorney would have read, but they were very short. So 3 minutes. Let's round that out to 5 minutes. Memorandum of costs. She probably just forwarded it to my ex. I doubt she cared. 5 minutes just in case. So that's going to come to 10 minutes. Affidavit of the kindergarten teacher. She might have read that more thoroughly. In fact, there might have been a discussion there between the attorney and my ex. I'm not sure, but there might have been one. And so I'm going to go ahead and say 10 minutes. I think that's fair, which is going to take us to 20 minutes. And then we got the report and recommendation for order. I mean, it's an order that hurts my ex, but what's the attorney going to do about it? She owes the child support. So I think 10 minutes, again, to be safe. That's going to bring us to 30 minutes. In attorney fees at the rate of $250 an hour, that's going to come to specifically $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.